Great. Well, I have to say, I feel a bit like a wildebeest in a room full of lions. I'm not an IP lawyer. I do international law, and I'm going to be speaking to you today about the international legal system for the protection of human rights. Now, this might be familiar territory for some of you, in which case, please do feel free to stretch your legs, refill your coffees, and come back for the next presentation. It might, however, be of interest to those of you who have not yet or not lately had occasion to examine either the UN system for the protection of human rights, which I'm going to talk about, or the European system for human rights, which also I'll mention, although more briefly. Okay, let's start with the document that is often called the foundational document of human rights, although this claim is a disputed one. I'm referring, of course, to the Universal Declaration on Human Rights adopted in 1948. Critical commentaries will remind us that the UN Declaration was not binding, it didn't come with any kind of enforcement machinery, and it was not particularly influential in its own time. Nevertheless, it did provide a list of enumerated rights, including civil and political rights and economic and social rights, and specifically referred to a right to own property. It was expected that the UN Declaration would soon be followed by an international treaty that would be binding and would come with enforcement machinery, but this did not happen for a much longer time than had been recognized. So it was in 1966 that we finally had two treaties, a covenant on civil and political rights and a covenant on economic and social rights. They were expected to be one treaty. They had to be split, literally due to Cold War constraints, where you had the West, which was keen on civil and political rights, not so keen on economic and social rights, and the East, which was keen on economic and social rights. The Cold War was also the reason why the two covenants, which are quite similar in structure, as you will see here, either of them do not refer to a right to property. They do have some other quite interesting provisions, and we'll come back to those in a minute. But I'd quickly like to mention some of the other treaties that are related to these treaties and form part of the UN human rights system. So these are essentially 7 treaties. The first of these is the Convention on the Elimination of Racial Discrimination. This, in fact, anticipated the two covenants. It was drafted by the same body that drafted the two covenants, but the apartheid context in South Africa led to an expedited push for this treaty and also led to its expedited entry into force. So this treaty entered into force in the 1960s, unlike the two covenants, which didn't come into force until 1976. Then there are 4 treaties that relate to specific categories of persons: women, children, migrant workers, and persons with disabilities. These treaties highlight the special needs of these categories and call for an end to discrimination against them. These treaties are all in force, but the membership to them differs quite widely. Then there are 2 treaties that address the human rights and security complex: the Convention Against Torture and the Convention Against Enforced Disappearance. Now, there are, of course, many other human rights treaties which have been adopted under the aegis of different bodies, but these 9 treaties, the 2 covenants and these 7 treaties, are together taken as constituting the core human rights treaties of the UN human rights system. These are, of course, not single documents. Most of these have a number of additional protocols that add to their guarantees and that provide additional procedures. Each of these treaties also establishes a treaty body. The 9 treaties together have a common secretariat, which is the Office of the High Commissioner of Human Rights. Now, let's look closely at these treaties and treaty bodies by focusing on the 2 covenants, the Economic and Social Rights Covenant and the Civil and Political Rights Covenants, and look at firstly some interesting provisions and then some of the functions that the treaty bodies perform. So in terms of interesting provisions, as I mentioned, there is no specified right to property in these covenants, but interestingly, both reiterate the right of all peoples over their natural wealth and resources. They also state that a people may not be deprived of its means of subsistence. And this becomes quite important in context of certain debates around traditional knowledge, for instance. And I think it's something that is going to come up in the next presentation. The Economic and Social Rights Covenant also has an interesting pair of provisions on the product of scientific innovation. It records, on the one hand, the right of all peoples to enjoy the benefit of scientific progress, and on the other hand, also recognize the rights of the author of scientific products to their to their creations. Finally, in a third interesting provision, Article 11 of the Economic and Social Rights Covenant recognizes the importance of international cooperation for the realization of the rights provided in the Convention. It is interesting because it records the importance of international cooperation. It also spells out certain forms that this cooperation might take, but it insists that this cooperation is not an obligation upon states. It is an act, it is a voluntary act. So states can choose to cooperate with other states to ensure the realization of rights in those states. Both the covenants indicate that the rights spelled out cannot be limited except as necessary for the pursuit of a specific and legitimate aim. At the same time, they set out rather differently worded fulfillment provisions, which you see here. The Civil and Political Rights Covenant provides for what are called obligations of result, that states must respect human rights, they must take the necessary steps to give effect to them, and they must provide an effective remedy to those who have been deprived of their rights. In contrast, the Economic and Social Rights Covenant appears to provide for a somewhat weaker obligation, the so-called obligation of conduct, a duty to take steps with a view to progressively realizing the achievement or progressively achieving the realization of rights. The provision is interesting because, as you see from its language, it recognizes that states do operate under resource constraints and that they can only act within those resource constraints. Moreover, it recognizes that developing countries in particular operate under specific resource constraints and that they may choose to limit the enjoyment of economic rights to their own nationals. Now, the language used in the Economic and Social Rights Covenant, in contrast to the language used in the Civil and Political Rights Covenant, suggests that the latter provides for a weaker set of obligations. However, interpretation suggests otherwise. So, in practice, the Economic and Social Rights Covenant has been interpreted as firstly providing for some obligations of immediate effect, so some obligations of result. These include no discrimination in affording rights protection and the obligation to take steps for the realization of rights. The idea is that states should not simply be able to say vaguely that they are taking some steps, but must show that the steps that they are taking are concrete, are deliberate, and are targeted towards specific outcomes. So some immediate obligations of immediate effect. In addition, and this is slightly more controversial, the Economic and Social Rights Committee also insists that state practice suggests that all states are under a duty to ensure a certain minimum enjoyment of economic and social rights to their people. They must ensure the satisfaction of certain minimum essential levels of rights, such as the right to food, the right to primary health care, the right to housing, and the right to primary education. And if the committee finds that a large proportion of people in a state are deprived of these rights, then it might find that the state is actually in violation of its obligations. So it reads in obligations to achieve certain specific outcomes into the language of the Economic and Social Rights Covenant, which otherwise, in terms of its own text, provides for simply an obligation of conduct. So in effect, the conduct-result binary tends to break down in practice, and it might be more fruitful to think of the obligations on states as being resolved into something called the RPF framework, the Respect, Protect, and Fulfill framework. The obligation to respect rights is simple. States are expected not to infringe upon rights as they are currently enjoyed. The obligation to protect is particularly relevant in the IB context because this is an obligation to create an environment in which rights are enjoyed and in which third parties, non-state actors, for example, do not violate rights. This is a due diligence obligation. States are not responsible every time that there is an infringement of human rights by a non-party, but states are under an obligation to show that they have done the best they could to ensure that these rights would be respected by third parties, and if they do find that the rights have been violated, they have done the best to ensure that they have investigated the violation and prosecuted it. Finally, the obligation to fulfill is the obligation to ensure a greater enjoyment of rights, and this can break down into obligations of conduct and result under either covenant, but in different ways. So this is a richer framework through which to understand what the obligations are upon states under these covenants. Okay, let's look at now what treaty bodies do to maintain oversight over the state's implementation of their human rights obligations. The treaty bodies, such as the Human Rights Committee established by the Civil and Political Rights Covenant, or the Economic and Social Rights Committee established by the Economic and Social Rights Covenant, are bodies of about 10 to 25 people who are independent experts, and they are expected to monitor implementation in a number of ways. The first way is quite simple. They are entitled to receive regular reports from states that speak to the states' achievements in fulfilling their human rights obligations. The bodies are allowed to receive these reports from states and supplement the reports received also from reports from other actors, including NGOs and national human rights institutions. They are supposed to consider these reports in a public session in the form of a dialogue with the state in question, and at the end issue a set of concluding observations which provide both an appraisal of the state's record and advice to the state on what it can do to improve its human rights record. A second procedure is that of interstate complaints. So states are allowed to bring complaints against other states' human rights obligations or other states' human rights violations before these committees. This is an opt-in procedure. It is a procedure that so far has not been used. States are evidently reluctant to bring cases against other states for human rights violations, not surprising. A third mechanism is that of individual communication. So here, individuals claiming to be victims of violations of human rights or claiming to appear on behalf of victims of violations of human rights can bring complaints before these committees. And this, of course, this is also an opt-in procedure, but where states have accepted this procedure, it has been widely used. So most of these committees, especially the Human Rights Committee, has been flooded with communications from individuals claiming violations of human rights. When these complaints are made, they are considered in closed meetings. It is rare for the committee to have oral hearings. It determines views by consensus and forwards the views that it forms to the individual and the state. In coming to these views and in making it, the committee acts in a quasi-judicial way. In a sense, it is making findings. It uses the language of decision. It uses language that reminds us of the language used in judgments. But strictly speaking, these judgments, these opinions are not legally binding, and there are no specific mechanisms for their enforcement. Some committees establish a specific office of a special rapporteur who is designated with tracking the follow-up on the committee's findings, but there is no binding basis that requires states to do whatever these findings ask them to do. Some national courts have suggested that the committee's views, the findings, could be more influential if only they were more richly reasoned. Then they might be influential on their own account. This is, however, rare. If you look at a finding, usually it tends to run into 1 to 2 pages, and the reasoning in it is rather spare. The committee simply states what the treaty provision is and what its own conclusion is vis-a-vis the state's record, detailing more the facts than its interpretation of the rules. Where the Human Rights Committee does contribute to interpreting treaty provisions is in the context of issuing general comments. So the various treaty bodies are entitled to issue sort of these comments speaking to either the text of specific treaty provisions or to certain themes that are relevant to the treaty or to specific procedures set out in the treaty, and to elaborate, therefore, on the content of the rights provided in those treaties. The general comments may be quite useful to flesh out the language of the treaty and even to update the language of the treaty, taking into account the evolving content of the human rights. However, although there is no denying the utility of general comments, there is a question mark over their authority. In practice, states have been careful to assert that these general comments are not binding. In this slide, for example, you see 2 examples, one of a state, the United States of America, and secondly of the European Court of Human Rights, rejecting the interpretations reached by the relevant treaty bodies, the relevant committees. They reject both the interpretations themselves and the committee's assertion that it can conclusively speak to the position in public international law as to the content of a specific right. Unsurprisingly then, general comments attract most support when they are seen as in line with the position in international law, and less support when they're seen as engaging in progressive development of international law. I'm going to turn to other components of the human rights system in a minute, but before I do, I just want to make a few points on human rights treaties and the specific features that they are claimed to have. Not all of these claims are well accepted. It is well accepted that human rights treaties give rise to erga omnes obligations, such that any state has the standing to bring a claim against any other state. The state bringing the claim does not have to show that it has been specifically injured or that its national has suffered the violation of a right. It is also accepted that purpose, the object and purpose of the treaty, should be taken into account in its interpretation. But it is not clear, that is to say, different institutions do not agree on whether purpose should override all other elements of treaty interpretation, such as looking at the ordinary text of the treaty and the literal meaning that it gives rise to. One suggestion is that in construing human rights treaties, it is important to make them effective. It is important to ensure the effective enjoyment of human rights, and therefore, the rights should be interpreted broadly and the exceptions to them should be interpreted narrowly. One might argue that this is also what is implied in the proportionality approach that some institutions adopt. But there is not a conclusive picture. Different institutions adopt different approaches to the interpretation of human rights. Another point of some controversy relates to reservations. Reservations are statements by which a state might qualify the application of a treaty vis-a-vis itself. Reservations are expected to be compatible with the object and purpose of a treaty, and the conventional position is that if they're not found acceptable in that regard, if they're found to not be in line with the object and purpose of the treaty, then the state is not considered bound by the treaty at all. The state, in other words, is given a chance to re-accede to the treaty without the reservation. However, in the case of human rights treaties, different institutions have argued that if the reservation is not found acceptable, then it should simply be ignored. The state should just automatically be considered bound without the benefit of the reservation. This is a position endorsed by the European Court of Human Rights. It's a position that has been endorsed also by the Human Rights Committee. Many states, however, are opposed to this position. A fourth point, which has both adherents and critics, is the argument that a state, by withdrawing from a human rights treaty, cannot withdraw the human rights protections that were made available to individuals under it. That is to say, once the treaty has been ratified and individuals have begun to expect that they have access to the rights provided for in the treaty, that expectation cannot be removed. Those rights cannot be taken away from the individuals simply by terminating the treaty. The rights are considered to have devolved from the text of the treaty to the ground. This remains a controversial position, with states, of course, insisting that the termination of a treaty brings to an end the rights under it. Finally, and this is a well-accepted point, a state cannot cite another state's breach of a human rights treaty as a reason to terminate the treaty for itself. Okay, let me now turn to some of the other elements of the human rights system. This diagram, I hope, helps us to pull back a little bit and see the place of the treaty bodies that we've been discussing so far in the context of other institutions that form part of the UN human rights system. So you see the treaty bodies mentioned in the middle. Most of these report directly to the UN General Assembly, except for the Economic and Social Rights Committee that reports in the first instance to the Economic and Social Council, which eventually reports to the General Assembly. In addition to these treaty bodies, you see on the left the Human Rights Council, and on the right, the Office of the High Commissioner for Human Rights, and I'm going to discuss both of these briefly. Now, the Human Rights Council, the treaty bodies that I was discussing so far were committees of independent experts. The Human Rights Council is an intergovernmental body. It's composed of 47 states, and it has a general monitoring function as regards implementation of human rights. The monitoring function takes three forms. There is a reporting procedure that is grandly called the Universal Periodic Review. There is a complaints mechanism, and there are some special procedures. The Universal Periodic Review runs in a 4.5-year cycle, during which each state is reviewed by reference to relevant human rights standards, which include the human rights treaties, but are not limited to those treaties. So its monitoring function relates to a broader universe of human rights. The review runs in 3 stages. which are self-evident. The first stage is that of preparing documents. So again, a state is asked to prepare a report on its human rights activity. This report can be supplemented by information gathered from other actors, so from NGOs and national human rights institutions, as well as from treaty bodies. The document preparation stage is followed by a review stage, which takes the form of a two-step dialogue between the Human Rights Council and the state. And again, the purpose is to discuss what the state's human rights record has been, the difficulties that it has faced, and what it can do to improve on its human rights performance. At the end of this review, a final outcome report is adopted, and this report provides basis for a follow-up at the next review stage. Now, the follow-up takes place certainly at the next review stage. So every 4.5 years, states will come back and report to the Human Rights Council as to what they did in the period between the last review and the present review. But there are also other elements to the follow-up. So states can be asked to provide midterm reports detailing the progress that they are making. And again, other institutions can be designated as monitors of states' human rights performance in the intervening period. And again, this includes the Office of the High Commissioner of Human Rights and a bunch of other agencies. The complaints procedure of the Human Rights Council is slightly different from the complaints procedure of the treaty bodies. The treaty bodies concerned complaints as to the violation of rights in individual cases. In approaching the Human Rights Council, the claim that has to be made is that there has been a pattern of gross violations. So complaints are not made on behalf of specific individuals. They're made in connection with a situation as a whole. That said, the complaints can be brought by victims who can say that not only were their rights violated, but that this violation is part of a broader situation of a broader pattern of violation. Or they can be brought by others who claim to have reliable knowledge of the violations. Like with the complaints procedure before the treaty bodies, the review of these complaints is usually kept confidential, but there is an important difference. The Human Rights Council has the option, if it thinks it important enough, to remove confidentiality. It has done so very sparingly, but on occasion it has decided to make public the fact of its review of a situation and to adopt and to establish a special rapporteur to oversee the situation there. An example of this is Eritrea in 2012. And this brings us to the special procedures. So one of the things the Human Rights Council can do is it can create several other offices. It can establish working groups, such as the Working Group on Arbitrary Detention, and special rapporteurs who are given either thematic mandates or country mandates to report on the human rights situation in relation to those themes or those countries. The Human Rights Council can also convene urgent debates, again, of the 47 among the 47 states that make up the Human Rights Council, and they can do this either during the regular annual meetings of the Council or by calling for special sessions. And they do this usually in relation to situations of crisis, either things like food and like the economic crisis, or by reference to situations in particular states. Okay, I don't want to say very much about the Office of the High Commissioner of Human Rights, except to note that firstly, it acts as the secretariat to both the treaty bodies and to the Human Rights Council, and it supports the work of the High Commissioner for Human Rights. The High Commissioner is sort of the chief advocate of human rights. The Office of the High Commissioner of Human Rights has a general role to play, firstly in human rights information, spreading human rights information and human rights education. It performs functions of outreach, it monitors on-ground situations, and it provides technical and financial assistance to states to enable them to fulfill their human rights commitments. Now, there are several challenges that this UN system faces. The first is simply the challenge of fragmentation. As we have seen, there are multiple texts, multiple instruments, multiple treaty bodies, multiple procedures, and all of these impose quite a great burden on states, particularly in terms of a reporting burden, where states are constantly being asked to prepare reports to submit to different bodies. Not just these 10 bodies that I have discussed, but there are also, of course, other human rights bodies under other human rights treaties. there isn't really a clear solution for this to the fragmentation problem, because on the one hand, although there is this multiplicity of treaties, that is also to be celebrated. Each of them performs a specific function. The answer that the treaty bodies have been able to provide so far is simply that they will work towards better coordination of their activities, including, for example, accepting a common report from all states, a common report between all 9 of them. A second issue, which is also challenging, is this question of what really is monitored and on what basis. So you have the language of the human rights treaties, but the language is, of course, quite general and doesn't by itself suggest the criteria by which you can actually evaluate whether the state has done enough in terms of fulfilling its human rights obligations. For now, states are simply asked to create their own lists of illustrative indicators which they can use as a basis for preparing their report on their human rights performance. But obviously, different states will privilege different types of indicators, so it is again difficult for a committee sitting far away to know if those indicators really provide the strongest possible basis through which to monitor the state's activities. There are efforts ongoing to develop a list of international illustrative indicators to provide a sort of template to states, using a set of, so in a sense, providing a list of criteria that they can use to report on their human rights performance. This may or may not be an improvement. It creates its own problems, including, of course, the problem of context. So what is going to be the basis of fixing on certain types of criteria as the most relevant to determine human rights performance? And how are those criteria going to provide much contextual information about the situation on ground in different states? So there are lots of problems in terms of, can these treaty bodies really effectively monitor human rights performance, or do they end up only really effectively monitoring the ability of states to produce persuasive sounding reports on their human rights performance? A third problem, of course, is compliance. I don't need to say very much about this. As you've seen, in most cases, the committee's work in terms of producing reports, recommendations, findings, all of which are supposed to be persuasive but are not binding. And there are very few mechanisms to ensure that states actually do fulfill the obligations that are elaborated. And this, again, there are no concrete solutions. It is just hope that by the establishment of offices such as that of the Special Rapporteur, because there will be a point person, there will be somebody who will have more of a capability of trying to persuade states to fulfill their human rights obligations. Now, to move on to quickly another point, civil and political rights and economic and social rights are often described as first and second generation rights. The literature also refers to a third generation of rights, which are collective rights. Although note that some of the rights listed here, such as self-determination or the right to natural resources, also finds mention in the covenants, such as the Covenant on Civil and Political Rights. Other rights, such as the right to development, may be the subject of a separate instrument, though not necessarily a binding instrument. I only mention this because this is, again, a theme that might come up later today. Okay, let me turn to the European system for the protection of human rights, and I'm going to cover this only very briefly. I just want to mention 3 instruments. Firstly, the European Convention on Human Rights, which was adopted in 1950, and the ratification of which was made a condition of membership of the Council of Europe. The European Convention on Human Rights provides for civil and political rights. Its original text did not mention a right to property, but a right to property was included in the first protocol that was adopted in 1952. The major accomplishment of the European Convention of Human Rights was the establishment of the European Court of Human Rights, which is possibly the leading regional judicial institution with a very influential body of jurisprudence on human rights. The European Court of Human Rights affords different mechanisms for the bringing of complaints. Cases may be brought by states against other states, although this is rather infrequent, or cases may be brought by individuals against states, and this is rather common. 3 quick points on the approach taken by the European Court of Human Rights. Firstly, the European Court cleaves to the view that the European Convention must be interpreted with a view to securing effective enjoyment of human rights, and so rights must be interpreted broadly and exceptions narrowly. In fact, exceptions must be shown as necessary and as tailored to achieve a legitimate aim that has been specified in the instrument. And this can include public order, public morals, or the rights and securing the rights and freedoms of others. And this is what we mean by proportionality analysis, that you have to justify the restrictions as necessary for and as tailored to achieving a specific designated aim. Third, nevertheless, the European Court of Human Rights accords a margin of appreciation to states. And this allows states, for example, to elaborate on what their conception of the requirements of public morals are. So the margin of appreciation recognizes that the context is different for each state, and that states should have some leeway to determine what they need to do to give appropriate effect to the rights provided in the European Convention. And there is no consensus on how broad or narrow the margin should be. The margin tends to be different depending on the right in question and the ground of exception that the state is claiming. The second instrument that I want to mention is the European Social Charter. This instrument was adopted in 1961, also under the aegis of the Council of Europe, but ratifying it was not made a precondition of membership to the Council of Europe. The European Social Charter, moreover, has a sort of a la carte quality to it. So in that, states are allowed to select the obligations by which they intend to be bound. The content of the European Social Charter is economic and social rights. Its scope is narrower than the European Convention. It extends to citizens and to lawful residents of states. In terms of its compliance mechanisms, there is no court. So the European Court of Human Rights does not hear complaints arising out of the European Social Charter. There is, however, a committee which has a complaints mechanism which is available to certain types of entities, such as employers' organizations, trade unions, and NGOs, and it has a reporting function. The third instrument is the European Union Charter of Fundamental Rights. This is an EU instrument, not a Council of Europe instrument, and it is a composite document that provides for civil and political rights, economic and social rights, and what the European Commission calls third-generation rights, such as the right to the protection of personal data. This is a slightly different concept of third-generation rights from the one that we saw earlier, but it does make reference to newly articulated rights. The EU Charter also makes specific mention of a right to property and specifically mentions a right to intellectual property. And this is going to be the subject of a presentation later today. The convention is addressed primarily to EU institutions and to states when they are implementing EU law. It relies on this is interesting, it relies on the findings of the European Court of Human Rights to fix the content of the rights provided under the EU Charter. So to the extent that both the European Convention of Human Rights and the EU Charter provide for similar rights, reference will be made to the jurisprudence of the European Court of Human Rights to determine what the content of the rights provided under the EU Charter is. Of course, the EU is allowed to provide enhanced protection, so it can go above and beyond what the European Court of Human Rights has found. The EU Charter does not provide for any additional complaint mechanisms. Individuals do have access to the Court of Justice of the European Union under the Treaty on the Functioning of the European Union, and it is and they have this access under certain conditions, primarily by showing that they have been subjected to direct or indirect discrimination. And it is by fulfilling these conditions that they can approach the Court of Justice of the European Union, also with reference to a violation of the EU Charter of Fundamental Rights. In its ruling, again, the Court of Justice of the European Union might apply proportionality analysis, in that it has to, again, reach the view that the restrictions that states have imposed are necessary and proportionate to objectives of general interest that have been recognized by the EU. Right, so that's the three relevant instruments relating to the system of protection in Europe. There are, of course, many other systems, regional systems for the protection of human rights, including the Inter-American system and the African system. But I'm going to stop here now and hand over to Henning to discuss more specific interfaces between human rights and intellectual property law. So thank you very much.